Hey, we love that umbrella guy. All right. Thank you.
He also admitted that he speaks to that umbrella guy, and you'll see that one text in there.
Oh, no.
MZ. That umbrella guy is the big lead of Johnny Depp's, positive social media that is
Wow.
putting negative out on
So
him.
much credit.
And he also
treading a thin line
seized
here,
the moment
Elaine.
and responded to the umbrella guy, the lead person for Mr. Depp's Twitters. Did you not?
Wait, what?
Twitter's the lead, man.
Overruled.
Facts not in evidence.
Mr. Umbrella Guy is the lead. The lead.
You
what?
know that he is
The lead what?
the most predictable.
I'm calling from Los Angeles, and I'm having a little problem under the name ThatUmbrellaGuy. I sent him my phone number at least 20 times in the chat and told him to call me. He ignored me, or I'm a man. I filed the report. If you guys could take a look at it and give me a call back, I would love to hear what you guys can do to help us. We really need to kind of stop this guy at least until Monday. I told him to call me, or I'm a man.
Rolling up, I'm feeling fly, yeah, I'm so damn fresh. Got that platinum grill, bringing in the chest. Diamonds in my mouth, shining when I speak. That umbrella guy, floss and speaking geek. Ice on my teeth, I'm dripping so hard. Platinum grills, I'm the king of the boulevard. Throwing money in the club, making haters mad. I'm the baddest in the game, no one gets a pass. Ooh yeah. Crushing all these lines, yeah, I feel fly. Rolling on the dubs, that umbrella guy. Iced out cold on the boulevard. You ain't a comic gangster, don't be playing hard. Ice on my teeth, I'm flying so high. Dropping the bass. That umbrella guy, one drill to rule them all, one drill to bind them. Baby, I'm so iced out, gonna blind them. Rolling in town, I'm an army of one. Doing verbal walk-bys, blazing like the sun. Riding in my whip, crushing false accusers. Dropping off the bass on the real abusers. Yeah. Living life fast, no time for the slow. Justice on my mind, stacking up on that flow. Life in the fast lane, no time to blink. Ice on my teeth, watch it when I speak. Chillin' on my rhymes, never missing a beat. Ice on my teeth, yeah, I'm living that sweet. That umbrella guy, bringing the platinum heat. Crushing every hater, no time for defeat. Ooh yeah.
Oh, yeah, indeed. What's up, baby? How's it going today, man? Very eventful day today. It's funny. The Fatson crew, they're like, oh, they're celebrating. If you haven't heard, I'll note this right off the bat. They did not get added to the lawsuit. Now, the reason for that, and we'll read the thing, is essentially it would leave MP and JC without a lawyer. It would impose a lot more time, let's say, is the best way to go. But the best thing about it is, this is what I was saying last night. That means that BBB is still the lawyer on this case. Like I was saying yesterday, you take them and you take BBB away. What happens if you get a competent lawyer? With BBB, I mean, my God, this dude. Oh, I mean, he is the best asset I've ever seen in a case for the other party. So it's kind of that would have been bad. Like if you would have added him again, I think there was a good case to be added for it, but ultimately, um, ultimately, it comes down to the other party being unduly burdened because they wouldn't have representation. Now that's fascinating because it's a weird message in the fact of a lawyer co-conspirator. I think that's a strange message to me, but we'll read over that. We also, there's a little thing that's funny that I don't think they're really catching on to. As far as the case moving forward, it's on. It is on like Donkey Kong. It is on for tortious interference, and it is on for defamation. The RICO conspiracy portion is not going forward, but everything else is. So the trial is on, baby. This is real. It is legit. And you got BBB at the helm. Oh my God, it is going to be some fun times. That also, again, they think everything is stacked in this basket. It is for them in a way. It is for them. In the fact, I think it's much easier to prove a case against LP and JC from Go. Like right off the bat, and then man. Everybody else. Woo, man. The celebration there was funny. All right, by the way, apologies for putting up a freaking stream so late. I didn't know I would. I had a wonderful ER visit last night. That's right. I had a wonderful one. Here's the weirdest thing with ER visits, by the way. Let me show you something here. The thing that really kills me. I'm fine, by the way. I'm good. I'm good. But the terrible thing is, look at this. Like they have all this room. Even if I watch them bring in like a emergency crash cart and everything else in the other room, they still have all this room, but they can't extend the little bed thing just a little bit more. I mean, it's not just like my feet hanging off the thing, my freaking ankles and everything else. I'm like, dude, I've been selling this for 8 hours. This is some shit. Not fun. Not comfortable. Not comfortable at all. I'm like, you pay how much money for this? Luckily, though, I have one of the oldest iPods in existence. No, actually, I have one. Remember these wonderful old things? I love the mode to it. I like to put it in my car too. It's got 160 gigs of music on it, man. This thing is that's like over a month straight of music. So just kick it, listen to music, and always come prepared. I always come prepared. Like it's really funny. I come with everything in its mother. That's what the people there. I was like, hey man, if I'm going, if I'm going to take myself over there, you bring everything. You bring a laptop, you bring a tablet, you bring something to game with, you bring a bag full of stuff. I ain't sitting in that thing and being miserable. It's already miserable enough. I'm at the hospital, but I'm okay, by the way. I just wanted to complain about the freaking beds, man. What is up with that? Come on. All right, let me pull up the chat here. I can't see you guys. My freaking chat closed out. Give me 1 minute. This thing is acting stupid. Just give me 1 second. I'm going to open the chat back up and then we get going. Oh, there we go. I lost the chat for a second. It freaked out on me. You have one of the iPods? Yeah, see, I love those. Yeah, I have a few old school iPods. That's one of the best about, you can either buy services these days that may or may not have what you want on it, or if you had music, it's nice. It's nice to have 160 gig. You couldn't put that on your phone these days or anything. They're pretty nice there. And they hold a charge much, much longer than, say, a phone where you have to have Bluetooth headphones. I just bring a wired headphone and go to town. I like to mow in that. That's the best way, or do lawn, blow out the leaves, that are out front, or walk around, whatever. I like to kick it in that. Bring that sucker with you. Relax and try to forget. part of you want to be able to identify what's wrong with you and not be panicky about it. So music helps with that. But anyway, today we had two things to discuss, actually. Oh, and by the way, if you like this broadcast, let's do two things here. Well, three things. First, tell people we're live, of course. The broadcast is live. Also, liking is free. Hit that little like button. And then, if you are so inclined and want to help out the channel, consider the Yo Breadstick monies. Yo Breadstick monies are always welcome. Especially, oh man, I forgot it was a new year too. God, racking up the hospital in a new year. Ugh. Okay, so two things happen. Number one of them by itself would have been like, yeah, this trial's going forward. Remember the mandatory mediation thing we were talking about yesterday? Well, the judge was like, you don't have to talk about that. So that happened. I told you there'd probably be a decision on that. So, yeah, it's fascinating. I find that interesting, too. Judge is like, you all have had to cooperate and communicate. You got to do this. You got to do that. By the way, you don't have to cooperate and communicate. It's like, wait a minute. Wait a minute. Now, his order says at this time to it as well, as far as mandatory mediation. So let me pull this up. I'm going to read this to you, and then I'll show you the order on that, and then we'll get to the add-in as well. Like I said, what this proves, you got the trial is on, baby. It is on like Donkey Kong. So when they told you, see, they want to pretend that somehow they were right about a case, and they told us a case would not continue. It wouldn't at all. And again, with the BBB thing, that was one of the things that people noted. Again, like I said, we didn't know if people would be added or not. I felt there was a strong case for adding two people. The other people I did not know about. I'm not saying there was not a strong case for them. But ultimately, again, I'm get added because keep terrible lawyer. That's pretty much it. That's the excuse. Oh, but anyway, okay, so this one first. Request to excuse mandatory mediation. Pursuant to blah, 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 the defendant respectfully requests the court to excuse mandatory mediation for good cause. First, the defendant's pending motion to dismiss under FRCP 12, directed at, for the 6 defendants in the operative complaint, if granted, would eliminate much of the plaintiff's potential claimed damages. Now, what it does is it focuses everything on C and LP. You think about that too. Here's the thing. When you're trying to prove a case, would it be easier to prove a case against 2 people or to prove a conspiracy? As an outside observer, when you streamline the case, it works both ways. So as far as BBB, if sure, BBB doesn't want to be added to this case. None of the Fats, they don't want to be added to the case. But at the end of the day, did this help out LP and Jason? No, it did not at all. They, like I said, they continue going forward with defamation and tortious interference. It's not good for them. But the defendants filed their 12B6 motion September 7th, and I believe those claims, those counts failed to state a claim that cannot be cured by amendment. This was demonstrated by the plaintiff's inability in his deposition to identify any statement by either defendant containing a threat of extortion or any claim by the defendants constituting tortious interference. The defendants believe those claims cannot proceed under the standard governing 12B6, and it is premature to mediate without knowing whether those claims will remain in case. So mediation may still be on, baby. Just look at what this is going to say with the decision. Okay, this comes in. Second, the defendants intend to file their own damages claims for themselves and Preston's minor child against the plaintiff under 18 U.S.C. 2261A/B, as well as state common law claims against harassment, defamation, invasion of privacy, intrusion, publication of private information, and appropriation of image. This is what they're telling you. This is what they're going to try to file against an army of people, I imagine. And it's going to be really fun and interesting because so many pieces of that, the more you claim, the more stupid you add on, the more you're going to have a problem. You know, oh, people weren't allowed to have concerns about a kid. Well, LP said, LP herself said, okay. That's going to be a fascinating one. Intention of infliction of emotional damages, malicious prosecution, and other claims. Remember, he's whining, oh man, we're gonna file our own stuff. Why are you talking about this right now, Brucey? I thought you told them in the thumbnail case that you can't even be talking about this till somebody's winning. Remember that? He's like, oh, by the way, you can't even discuss this stuff. Oh, man. These claims arise from plaintiff having targeted defendant in nearly 200 YouTube videos, May 2023 and ongoing, making their lives into an online spectacle for entertainment and profit. There would be no reasonable expectation that mediation could resolve the disputes between the parties considering these impending claims. Third, although claims of vexatious litigation based on the present action would be premature because it's not yet terminated, the defendants believe the present lawsuit is vexatious and contrived to fulfill the plaintiff's YouTube storylines that have made the defendants and Preston's young child the involuntary subjects of nearly 200 videos. This is May 2023. Here's the thing they run into. You can make as many fucking videos as you want about a subject. As many. These people, they think that they're going to walk with that. It's going to work. All it is they're telling you, August, it ain't going to be over. Well, let's see how that federal decision rolls in. Streamlined as it is, it's going to be even more interesting. So in addition to the above listed claims, the defendant will add claims for vexatious litigation if and when, as they expect, the present lawsuit terminates in their favor. Wow, what's that old thing about counting the chickens before they hatch? There's no reasonable expectation that mediation could lead to a resolution of the dispute between the parties because any settlement of the present lawsuit would prejudice and in fact defeat the ability of the defendants to pursue their vexatious litigation claims. You remember, now they're telling you right here, things are going to go forward. They know. It's fascinating because you've heard these people say over and over again that somehow in some way this stuff is still going to settle. How? I don't know. Didn't understand that. We're not going to have a trial. Trial's not going to go forward. How? What are you basing that on? Every indication is trial is on, baby. And yeah, it's definitely on after that. Finally, the defendants are indigent and cannot afford the costs of formal mediation. They don't have the money. They did not choose for the plaintiff to sue them. If there arises a prospect of settling, see, they still are banking for that hope for settlement, baby. They're open to a settlement conference with a magistrate whenever it would be appropriate. Fuck them in settling, by the way. I would not ever. I wouldn't let them worm away. I would not. Additionally, the parties may request a settlement conference before a magistrate judge in lieu of mediation. The defendant's limited means should be considered in excusing them for costly mediation that is unlikely to succeed. More so given the plaintiff's publicly stated purpose of using this litigation to inflict financial burden. Now, the decision comes in on this. It's like game on then. I'm going to call this the game on statement. For now, by the way. So we have, upon consideration of the foregoing, it is ordered on the 17th, that would be today, defendants have filed a motion to excuse mandatory mediation. No response necessary. Now, it is interesting that all these claims are made. No response is necessary. Now, one thing that I don't find, I think the judge does Jeremy a lot of favors in this stuff, just to be honest. Not saying any undue favor. That's not what I mean. I'm saying streamlining litigation and everything else. But it's funny, all of these things that are said, the judge is like, hey, you don't even have to answer this. Now you think about it. If you were considering all of this just blather that Bruce is spitting out there, you give you a chance to freaking go out and actually answer that, would you not? But there's no response necessary. Upon the court's final scheduling order, a party may request the court to excuse the mediation requirement upon showing of good cause. Defendants have shown good cause to excuse the mediation requirement, at least for the time being. At least for the time being. Isn't that interesting? Therefore, mandatory mediation is granted to the extent that mediation requirement set by the final scheduling order is suspended until further notice. It's suspended for now until at least for this time being. So we'll see. We'll see if that ever comes up again. Maybe, maybe not. Now the other thing, and this has been interesting because, like I said, I personally, one second, oops, shit, I hit the wrong button on that. I got to go back to my document. Close the document out. Give me 1 second here. Let me see if I can blow it up anymore. Yeah, there we go. 200% looks good. All right, here we go. Check this out. So this is the addition order. The order talking about adding on LP, or rather anybody besides LP and JC. Now it's interesting because background, we'll read all of this too, but you get to the whole discussion on it. And what's fascinating about it is, again, the judge is telling you essentially, again, it's a long document, by the way, but in this, one of these individuals is Bruce Manskin, the attorney of record in the case for defendant Preston and Cook. The proposed amendment complaint seeks to bring claims of tortious interference with business relationships, civil conspiracy, and aiding and abetting against Mr. Manskin. Now, he's licensed in Massachusetts, and therefore is subject to Massachusetts rules of professional conduct. Under Rule 37A, a Massachusetts attorney shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. Comment 1 to Rule 3.7 states that combining the role of advocate and witness can prejudice the tribunal, opposing party, and can also involve a conflict of interest between the lawyer and client. All of this is to say that Manskin would be unable to continue representing Preston and Cook if he were joined as a co-defendant. That is so because if he were joined as a co-defendant, it's inevitable that he would be called as a witness in the trial, the same trial where he'd be representing Preston and Cook. At such the trial, rather, he'd be placed in a tenable position of attempting to look out for his own personal interests while simultaneously looking out for the interests of them. Additionally, there's a serious risk that your jury may be confused were he to appear at the trial as an attorney, a witness, and a party. So you see, when you look at this, you see why this is happening here. It's not saying, yo, buddy, you're free and clear. What it's saying is, right here, right now, well, there's a little problem. but celebration, huh? Oh, man. I mean, I think the most favorable position this guy gives you is in being the lawyer. I think as the lawyer, continuing to file, Lord, I think that he is the gift that will keep on giving. I mean, if the Shara depot and many of the other filings are any indication of what you may be looking at as you go forward, oh yeah, baby. So let's read this whole order together. It's like I said, it's not a short order, but it's fun times. So check this here. So Jeremy B. Hales v. John Cook et al. Order. This matter is before the court. Plaintiff's amended motion to leave to file amended complaint. Defendants have responded to opposition. No hearing is necessary. For the reason below, the motion will be denied. So, background. The litigation began March 4th, 2024, when the plaintiff filed a complaint against two people, LP and JC. On a 16-page complaint, plaintiff alleged that the defendant, Preston and Cook, committed defamation, violated Florida's Civil RICO Act, and tortiously interfered with business relations. Defendant moved to dismiss the RICO and tortious interference claim. Before the court could rule on the motion to dismiss, the plaintiff moved for leave to file an amended complaint. And before the court could rule on that, the plaintiff filed an amended motion for leave to amend along with a new proposed amended complaint. It is the amended motion that is currently before the court. Okay, so they note the filing of the amended motion for the leave to file amended complaint mooted the previous. So if you understand, when you amended it, you basically threw away the other one. Okay, it's like that. Ignore that. Doesn't exist anymore. So what they're looking at again is the amended motion instead of the plaintiff's motion. And that's what they're pointing out with that. Now, in that motion, plaintiff sought leave to file a 62-page amended complaint that would add numerous new claims and join 6 new defendants. Defendant Preston and Cook have responded in opposition. They have argued that the motion should be denied on the grounds of undue prejudice, undue delay, and futility. Now, discussion. Rule 15A of the Federal Rules of Civil Procedure governs pretrial amendments to the complaint. The 21-day deadline for amending the complaint without court approval is coming on. See Federal Rules of Civil Procedure, allowing amendment without court approval if filed no later than 21 days after service or the filing of a responsive pleading, a Rule 12B or E motion. Plaintiff, therefore, may amend his complaint only with the opposing party's written consent or the court's leave. Now, because defendants have not consented, plaintiff requires the court's leave. A court, quote, should freely give leave when justice so requires, but leave to amend is not an automatic right. Instead, the decision whether to grant the leave to amend a complaint is within the sole discretion of the district court. And they note certain claims here. The district court has broad discretion to grant or deny leave to amend. In the exercise of its discretion, a district court may defend leave to amend on the grounds of undue delay, bad faith, dilatory motive on the part of the movement, I keep saying movement, undue prejudice to the opposing party by virtue of amendment, and futility of amendment. So the question before the court today is whether any of those grounds for denying the leave to amend are implicated by plaintiff's proposed amended complaint. And the answer is yes. The grounds are undue prejudice. Again, that would be the issue, someone like Bruce Manskin, and undue delay, which is fascinating considering they're like, hey, we should be able to move forward. Wasn't this the same guy, by the way, that was bragging about delaying 5 months? Isn't that fascinating? So you're supposed to actually be able to move in an expedient way, unless Bruce Manskin wants you to. Isn't that fascinating? Better not try to slow things down again, Brucey. That's what I'm smelling in this. That might cause some problems. Of the potential grounds on which the leave can be denied, perhaps the most important factor and the most frequent reason for denying leave to amend is that the opposing party will be prejudiced if the movement is permitted to alter his pleading. Now, again, they note quite a few items in this, and this explaining that the most important factor to consider in deciding whether to grant or deny leave to amend is prejudice to the opposing parties. Courts typically find undue prejudice, quote, when the amendment unfairly affects the defendants in terms of preparing their defense to the amendment. Now, in the proposed amended complaint, plaintiff seeks to add claims against 6 new individuals. Remember, you had an army of individuals that were potentially going to be added to this. And again, like we were saying, one of those is Bruce. Now, all of this building to it. Remember, what this is telling you, if you don't understand this, if you file within 21 days, so if they would have filed and then within 21 days, they were like, screw it, we're going to add all of these people, then that would have been an automatic yes. After 21 days, it falls to the court to decide whether or not you can do this. And they have to look at specific elements. And one of those elements, again, 2 of the is delay and prejudice. So when you look at it, the 21 days, they wouldn't have been able to do because a lot of the information that you already had out there, it didn't include many of the bombshell revelations that not only, they would include somebody like a Bruce Manskin, but they also are problems for LP and JC. You know, none of that stuff has been thrown by the wayside. That information is still valid and relevant. You know, stuff about threats. Stuff about potentially having a hitman. Letters and more. but so in the proposed amended complaint, I have 6, and one of them again is Bruce Manskin, the attorney of record in this case for defendants Preston and Cook. Now, the proposed amended complaint seeks to bring claims of tortious interference with business relationships, civil conspiracy, and aiding and abetting against Mr. Manskin. Now, Mr. Manskin is licensed in Massachusetts, and therefore he is subject to the Massachusetts rules of professional conduct, too. Now, although Mr. Manskin is not licensed in Florida, the local rules require him, as an attorney admitted, to appear, I still want to say pro hoc vice, I still like that, pro hoc vice, to comply with the rules of professional conduct promulgated by the Florida Bar. Now, again, it notes rules on. These rules similarly prohibit an attorney from serving as both an advocate and a witness. So again, what you would run into here is an issue. Could he continue as their lawyer? That would be a real problem. That's what it's talking about for that. So under Rule 3.7a, the Massachusetts attorney shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness. Now, comment rule to Rule 3.7 states that combining their role as advocate and witness can prejudice the tribunal and the opposing party, and can also involve a conflict of interest between the lawyer and client. Now, all of that is to say that Mr. Manskin would be unable to continue representing defendants Preston and Cook if he were joined as co-defendant. See, here's where your problem comes in. This is really what the judge is deciding on. And this was a comment. This is something that a lot of people ask questions, including ourselves. What would happen if you actually had him added? Well, it would be a problem. They would have to get somebody else added to the case. That would be a tremendous issue for them. And Again, the judge gets to decide on whether or not it happens. Again, I think there's a lot of proof that put Bruce in as a co-conspirator. It's just in this particular case, baby. Yeah. You better win this case, Brucey, because if you don't, boy, you are fudged up, son. That is so, because if Manskin were joined as a co-defendant, then it is inevitable that he would be called as a witness at trial. The same trial where he would be representing defendants Preston and Cook. At such a trial, Mr. Manskin would be placed in the untenable position of attempting to look out for his own personal interests while simultaneously attempting to look out for the interests of the defendants Preston and Cook. You know, and again, that is very true too. You know, you can't go out and say that, like, again, let's pick out Shizzy Wiznut. Today, Shizzy, you're going to be my lawyer. If Shizzy, for some reason, was going to be my lawyer in a case, and Shizzy also ended up being involved in a case, well, you could see that. How would he be able to go out and to look out for my best interests if at the same time they come in conflict with his best interests? Like maybe throwing JC and LP under the bus would be in the best interests of Mr. Manskin. Now, if so, how is he going to look out for his best interest again and theirs? Because as their lawyer, he's supposed to be there looking out for their best interest. Kind of, you see a problem there, right? And that was a discussion that came up. How would that be addressed? So here's C in front of the 11th Circuit, 2001. Recognizing that the roles of an advocate and a witness are inconsistent. This has been cleaned up, by the way. You know, there was a lot there. It just said, okay, you can't be both. You can't be an advocate for somebody and also be a witness. Additionally, there's a serious risk that the jury may be confused were Mr. Manskin to appear at trial as an attorney, as a witness, and as a party. That would be confusing, would it not, by the way? You could see that. And that could actually be a real confusion, not just for LP and JC, but that could also run into some issues where Jeremy Hales is trying to set down facts as well. Because how exactly would that come together where BBB, he gets to argue his own points, he gets to argue them for a jury? I mean, how would you handle so many issues that would come up? You couldn't. You absolutely could not. It wouldn't work. So the comment at recognizing that the trier of fact may be confused or misled by a lawyer serving as both advocate and witness. Notice this: the trier of fact may be confused or misled. Not just confused by something, they could potentially be misled by that. So, as they know, because such conflict and confusion is precisely what the rules of professional conduct seek to avoid, Mr. Manskin would be required to withdraw or be disqualified by the court. So the court would have to be like, yo, you can't be this anymore. So he would either have to voluntarily step aside, or the court would have to say, we're going to remove you. Although it says in certain situations, courts have permitted an attorney to serve as both an advocate and a witness, there is no way the court would permit Mr. Manskin to represent defendants Preston and Cook at a trial in this case while simultaneously attempting to represent his own interest as a witness and named defendant. The risks, they are way too great, and the Potential pitfalls, way too numerous. Oh, yes, indeed. Oh, yeah. I mean, you could see that right now. That would have been, again, there was no way, like it had been already discussed. If he would have been added, they would have had to remove him because there's no freaking way that a court would have allowed that. The risks, they're way too great. And they are. That would have been way too much risk. And the potential pitfalls would have been way too numerous. Let's see, where are we there? From representing them when the proposed amendment complaint accepted. Now again, see where disqualifying an attorney because an attorney may not act as both an advocate and witness in the same proceeding. Now, accepting the proposed amended complaint, therefore, would deprive defendants Preston and Cook of their legal counsel midway through the litigation. So we're already moving on. So removing them right there. At the start of this, defendant Preston and Cook were proceeding pro se until Mr. Manskin agreed to represent them. Maybe the judge needs to be reminded. They were quote unquote pro se, but he was still filing items, which is very much his own statements against rules in the court. So they were quote unquote pro se. Yeah, not really. But given the limited financial resources, this should be a fun discussion going forward too. Their limited financial resources? That could be a really interesting discussion about how much money has been coming in. By the way, apparently there was a big whining spree because I said yesterday that the proper authorities would be contacted if there wasn't transparency through the end of this week about the money that they've been raising. So instead, they're whining and pretending to be victims. Look, it's a simple request for transparency. And some of these folks out there, they believe that the only people that you owe transparency to are the people giving money. Oh, no, that's not how that works. You cannot scam people. That's not how that works at all. You have to have forward-facing transparency. I mean, you think about the idea that how many scammers have you seen taken down? And isn't it amazing? In order to avoid public transparency on where money is, they cry victim anytime you talk about, man, proper authorities should be notified about this. Because again, there are people there that have very questionable, still hitting their record as far as money and potential scams would be concerned. Like, don't you think that's a problem? Apparently they don't, though. Apparently they want to cry victim about that. Instead of just, again, all of this could very easily be fixed if. But no, no, can't have that. Can't have transparency. Isn't that amazing? I mean, it should have been there from go. That's why places like GoFundMe, that's why, first of all, that's why YouTube has its own terms of service for fundraising. You think that's because they just set those down arbitrarily? No. That's because they want to avoid legal liability. They want to avoid promoting scams. So when you're talking about money that is being earned, again, there's supposed to be a goal. You have a stated purpose, but also a goal. Where money goes when it's involved with that. All of this stuff there shouldn't be just something that random people are contacted for. They should actually have that. Everyone should. Oh, that's amazing. It is amazing. The deflection on that is something else. Okay. So I guess that's the answer to that, huh? That it's, oh no, we're being targeted because we're the greatest people ever. No, just show fucking transparency. It's very easy. It's a simple request. Your own people that donated money ask for it. See, to say that contacting authorities about a potential scam is a threat, the only way you could see that as a threat would be to be running a scam, because otherwise, I mean, what would be the issue? And the whole answer has been, oh man, well, we did that again. If you received $100 and you said all this money goes to whatever stated goal, but you're only spending $30 on stated goal, that's not the way that works. It should be investigated, but it shouldn't even have to go that far. It should just be transparency for transparency's sake. You would think that people that have been involved in giving money to this, substantial amounts of money, mind you. I mean, we're talking quite a bit of money that is moved. Just through the, YouTube, there's tracking to see how much money goes through channels. Now, it doesn't tell you memberships and more, but it does tell you how much money is gained through a channel. Again, on those dates where people were talking about giving money for, there was no stated purpose in the very beginning, saying that, well, you had to earmark, like if you gave $50, you had to mark it and say it was for X or for Y. No. It was talking about gathering money for. So to go back afterwards and to say, well, part of that is this and part of that is that, and then to change the rules upon it again, that is an absolute mess. But anyway, I got way off course on that one. Still, I did want to point that out there, though. Welcome, by the way. There are over 3,000 of you today. Like I said, the key takeaway for this document here today, for me, like I said last night, adding these people, well, that would have been interesting. The only thing would have been that you would have had a lawyer change. And the lawyer change, like Jeremy said, Bruce is the best lawyer for him that he has never had to pay for. It is true, man. I mean, some of the stuff he's done is ridiculous. He didn't even know what court we were in. Like the last thing that came in we talked about yesterday was him must move to Gainesville. And the court was like, yo, dude, we're in Gainesville. Anyway, sorry. Okay. Given the limited financial resources of defendants Preston and Cook, the court has been informed by defendants Preston and Cook are of extremely limited means. That's in document 54. Okay, now this, you can actually comment about that. And they have put in a filing. If there are extremely limited means, if they've had a cash infusion, and they are going out of their way to try to put money and park it in someone else's bank so they can get around that, that is a real problem. That is a real fucking problem. Raising money and then trying to obfuscate the sourcing. Trying to say, we didn't actually get any money at all. No. Through this roundabout way, somehow we don't actually touch it. Yeah, no. She actually made a comment about them having money too. With one of the Northport things that came up, she actually said, now we have money. I mean, again, these people are their own worst enemies. Like their counsel should have been out there saying, hey, you know what would be a great idea? Shut the fuck up. That would be the smartest thing. But you know what? Their own counsel can't do that. And if their own counsel can't do that, then how do you expect them to do it? They're taking their cues. They are probably some of the worst people you could represent because they themselves are such a disaster. And that's where your counsel should come into play and actually keep this stuff, just keep it forward facing in a way that, again, it looks presentable. It looks good. But what do I know, right? What do I know? But limited financial, and the court is concerned that they would be forced to return to pro se status if Mr. Manskin drew or was disqualified. Certainly, losing counsel and having to defend themselves pro se against the allegations in this case would unfairly affect the defendants in terms of preparing of defense. It would also further complicate the case because a litigation involving pro se litigants is notoriously more problematic than litigation with counsel litigants. Really, I would ask a judge this, and again, no shot at the judge. I'm just saying this. Do you think that in a pro se case, do you think that the litigants would know where they're at? like what court you're actually in? Because in many of these things, I cannot tell the difference between pro se statements. They may clean up nicer. You may have somebody clean these things up and say, oh, yeah, look at this example, look at that example, and more. But the underlying statement of, I want to move this to a different place. So wait, you're still in that place. It's the same place. Oh, God, man. So, notoriously more problematic. Woo, man. Oh, my goodness. And even if the defendants, Preston and Cook, were able to find replacement counsel, there would be a significant delay in this litigation because they would first need time to find and retain new counsel. New counsel would then need time to get up to speed. Now, as far as delays, see, this is another issue, which is, like I said, it's a fascinating conversation considering counsel for the defense bragged publicly about delaying these proceedings for 5 months. But suddenly in his filings, time became an issue. It was like, we need to have expedience. And it's like, wait a minute, weren't you just bragging about slowing this down to an insect crawl? We'll ignore that. Let's just ignore that part, right? Oh, my God. But yes, as far as delays, courts, they have a very busy dockets too. They don't want delays either. They want to be able to pull this together. They want to set down a schedule, and they want, to the best of their ability, to keep to said schedule. So a delay would be a real concern, as they're saying here. So speaking of delay, granting plaintiff the leave to file the proposed amended complaint would unduly delay the resolution of this case. Quote, prejudice to the non-moving party is not the only factors courts consider when determining whether to allow leave to amend. Undue delays may also clearly support denying the leave to amend. Now here, the plaintiff's 16-page complaint is a relatively straightforward one that names 2 defendants, and it brings 6 counts, 3 per defendant. Now the plaintiff's 62-page proposed amended complaint, on the other hand, is convoluted, and it seeks to add 6 new defendants and many more complaints. So again, what they're talking about here with timeliness, you have a straightforward item that is aimed at, see, this is where LP and JC needs to understand something. They are very much in the jackpot. In fact, what this is telling you is that it would have been a harder case to prove. It would have been more convoluted to put on. You would have had more representation, more attorneys, more delays, more difficulty putting this thing together if they were standing with an army of foes. So, who's this a favor to? Well, it's certainly not a favor to LP and JC. Not at all. Because, again, 16 pages. It's relatively straightforward. Names 2 defendants, and it brings 6 counts. Again, as opposed to 62 pages of amended complaint, adding 6 new defendants, many more counts. Now, granting plaintiff the leave to file the amended complaint would greatly and unnecessarily expand the scope and complexities of this lawsuit. This proposed expansion would cause substantial delays in the disposition of any case that is nearly a year old. Yeah, 5 months of that belonging to one guy. By the way, the guy, of course, that totally took credit for it. Again, that would be something I would slip in to further documentation. Allowing a plaintiff to amend his complaint may unduly prejudice a defendant if amendment would delay the litigation or expand the allegation beyond the scopes of the initial complaint. Also, seeing also here, explaining that an amendment may be unduly prejudicial when the defendant would be put to added expense and the burden of more complicated and lengthy trial. Now, there are several ways in which granting plaintiff leave to file the proposed amended complaint would unduly delay this lawsuit. So it's describing why would this slow this down here? What would be the problems in it? Now, first, the 6 new defendants, they would need to be served with the amended complaint. Yes, so everybody would have to be served. They would have to be added in. The potential service issues could arise, as they often do, which would delay the case's progression. Even if plaintiff perfected service without issue, each new defendant would have at least 3 weeks, assuming no extensions, for their respective dates of service to respond. So you see the add-ons. You can see how that would add on by itself. Even if, when you go in with service, even if it was perfect, you're adding on weeks to that. That would slow things down. Now, for any new defendant who waived service under Rule 4D, the response deadline would be 2 months from the date the waiver was sent. So again, I mean, you look at how much time could potentially be added to that just from that portion alone. Now, second, each of the 6 new defendants would likely engage in motion practice. This would be an absolute logistical nightmare. This is something we did talk about before. If you added in everybody brings in their own lawyers and they start papering the shit out of this would have gotten messy. It would have looked ugly because every time something came up, you would have people trying to paper this, delay it. And this is actually, it's not just a problem for defendants in that. That becomes a problem for Jeremy, because what you see there is you see a way that these folks could really take the costs of something and they could push it up to insane levels. If you had, they're already insane levels, by the way. The money that you have in, I mean, it's already crazy. But adding them in and allowing them to paper this case, and you've seen people do that. You've seen one person significantly delay this case already. And what the delay in that case for Jeremy Hales meant is it meant money, because courts run on money. So for all of them to be able to go in and again do God knows what, that could absolutely be a mess. So yeah. So plaintiffs would have 2 weeks to respond to each respective motion and 3 weeks to respond to any summary judgment motions. The court would then need time to consider and resolve each motion. Therefore, it is likely that adding or additional motions practice for the 6 new defendants would substantially delay the final disposition of this case. And that is very much true too. I mean, you're talking about significant delays when you look at it like that. That lay out a lot of time. Lastly, joining 6 new defendants and adding a multitude of new claims would negatively impact the discovery process, a process that has already been ongoing for several months. The 6 new defendants would need to conduct their own discovery and plaintiff would also likely seek to obtain new discovery from each of the 6 new defendants. It is possible, indeed, likely, given the history of this case, that discovery issues would lead to filings of motion to compel. Look, here too, the court is talking about that. The court is like, hey, this wouldn't go smoothly. Because I wonder why that wouldn't go smoothly, by the way. I wonder who is being told that they're being the court is being asked, rather, to compel the discovery of. Now, the court would then need time to rule on each motion, which adds further delay to the progression of the case. It is also likely that discovery that has already been completed would need to be redone. For example, plaintiff has already been deposed by defendant Preston and Cook. And that is true. Here's the thing. Plaintiff, as far as his deposition, it's over and done. All of that, see, I heard this too the other day, and I thought this was actually kind of funny. They were like, well, what about this? What about that? Well, what about it? Why the fuck didn't you ask that then? You had the guy, not only for the hours, but you got extra hours. Why weren't you asking that before? Because you already had your deposition. If you wanted to ask the man something, maybe you shouldn't have spent hours upon hours bungling through something to the point that Judge Potted Plant actually had to get involved. He had to say, wait a minute, maybe ask some stuff that's relevant to this guy. I don't know. What do I know, right? What do I know, indeed? But plaintiff has already been deposed by defendant Preston and Cook. But the 6 new defendants would likely seek to depose plaintiff again for their own discovery purposes. And yes, that is true too. That is true. They would actually try to depose him. They would do, God knows. It would be such a fucking mess. It would be an interesting shit show to watch, but it would be a crazy one too. What is that? Give me a second. SC, that's funny. I heard my phone go off. I was like, what is that? Sent a cash app, and it was for flea dirt money. Thank you for the flea dirt money. I was like, what is that? What was that there? That's hilarious. Okay. For example, though, the 6 new defendants would likely seek to depose. It is inevitable that permitting the amended complaint would substantially lengthen the discovery period, require a modification of this positive motions deadlines, necessitate a new trial date, and ultimately delay the resolution of the matter. Yes, that would indeed happen. The whole timeline that you were setting on, there's no way, because even if we're not talking about just a timeline that say in some world, Jeremy's like, yeah, everything sticks to it. We're good to go. Well, no, every one of those people would be like, nope. We got to do this. We got to do that. We're going to delay this. So yeah, you knew. We talked about that too. We were talking about significant time additions to the case. Remember this too. This is talking about this case. Just to make this clear, it's talking about this case. Okay. So you end up losing a case or something. Ooh, baby, you better win this shit. Oh, BBB, man. You better win. Because my God, you were looking down the barrel of some frosty stuff. He's already out there. Again, he spent more time making threats about DUI guy and writing letters than actually focusing on what he should be with the game on. But see lover, see that lover, stating that the Joinder of new parties would undoubtedly necessitate further extensions of the discovery deadline and would delay the ultimate resolution of the litigation. Now, at the end of the day, the court is convinced that granting plaintiff leave to file the proposed amended complaint would unduly prejudice defendants Preston and Cook. The court is up. Have they been calling him Cookie the whole time? I thought I saw that earlier. It doesn't matter. I should have been calling him Cookie there. I mean, considering we know how his cookies spelled. But the court is also convinced that granting leave would significantly expand, complicate, and delay the ultimate resolution of the case. Again, stating that if the court determines that the proposed amendment would result in defendant being put to the added expense and the burden of a more complicated and lengthy trial, leave to amend may be denied because the interests of justice would not be served by granting plaintiff leave to file the proposed amendment complaint. The court will exercise its discretion and deny the plaintiff's motion. So again, as far as the original 16-page two-party, yeah, as far as the amended complaint wanting to add 6 new people, no. So BBB remains as the Lord. We'll read the rest of it. But again, like I was saying at the beginning, is that really a loss? Who is it a loss for? I mean, if everybody agrees here, the BBB is pretty much a weapon that sometimes, oftentimes, I'm going to add, worked against his own clients, then who exactly does that benefit? Does that benefit JC? Does that benefit LP? Or does that benefit Jeremy Hills? Also, when you look at these statements here too, in going after justice, when you complicate matters, you do have the potential of complicating something to the point. If you sat down in front of a jury, have you ever looked at a jury pool? Have you ever sat down and actually looked at a? Imagine this. Okay, here's the best way to do this. Okay, the next time you watch a video. Like the people of Walmart, you know, those videos where you see people at Walmart doing the stupidest freaking things known to man. Imagine that being your peers. Those are your peers there, right? Now imagine trying to explain something complex to a jury of your Walmart peers. Now, you know, when you think about your peers, oftentimes you think about, you know, your professional peers. Like if you're out there in the world and, you know, you see the best of the best sometimes, you know, the best and the brightest. But that's not typically where your juries end up drawing from. They draw from people that have nothing in their days going on. A lot of times, people that either were too dumb to get out of jury duty, or they didn't want to, you know, and that's not always the best thing. Again, I'm not saying everyone in a jury pool is the people of Walmart. Sometimes they get it very right, but it needs to be straightforward for them to understand it. A straightforward thing is something like, I don't know, hey, there were signs that were stuck out by a roadway, signs that one party in this seems to have admitted that one of them posted, and these signs are so egregious that you don't even have to prove damages because what was said is so horrible. These same parties have been sitting around making threats to someone who was so concerned that when they were covering it, they decided that they no longer wanted anything to do with these people. Like, that's pretty streamlined stuff. Now, again, you can make the case. I'm not saying the case can't be made for all of these other people. But when you think about it, here's the thing, like in this particular thing, which one do you think has a better chance of concluding in a way that benefits Jeremy Hales? Do you think 6 new people plus 2 people, you have 8? Do you think, again, the reason I ask that is, who do you think this is doing a favor to? You know, they're out there, you know, hurrah-rahing and pumping their fists. They're not out of the woods by any stretch of the imagination. They're just not looking at down this one. They may feel a sigh of relief, but holy shit. And that might make them say some pretty dumb and awful things as matter of record, which they have done many and many a time without ever providing proof. Remember, I mean, we're talking about idiots that have gone out and made many statements that they said, oh, proof is coming soon. And they never bothered to bring up any proof. Ever. Just fascinating stuff. The best thing that they had going for them right now was Jeremy Hales is driving on the wrong side of the road when he drives by their property filming. And we saw the Shara video, the last one, where that road, yeah, it's like you have a vehicle and then a tire beside the vehicle. That's the road. There are many roads like that around here, by the way. And what's fascinating is these people they drove on those too. So they know how those roads are. They actually know how they were. But these people are canvassing neighborhoods, making crazy statements. They're not out of the woods. They're just out of this particular neck of the woods right this second. And again, the greatest weapon in Jeremy's arsenal, in my opinion, the LULYER, is still in play. Today, ladies and gentlemen, this is a good day. I mean, that's what I was, like I said, that's what I was saying last night. Go back and listen to it. Like, either way this went, would have still been funny for me. Because if he got added, I'd be like, holy crap. Oh my God. But if not, holy crap, we're gonna get more of these. Where is Gainesville? We're gonna get more of those. Oh my God, I love it. So, conclusion. For reason above, it's ordered that plaintiff's motion to let's start again. Plaintiff's motion for leave to file amended complaint. That one is moot. Okay, so this one, like it said and explained before, this file doesn't exist because there was an amended file. Anytime you have, again, an amended file, it makes the last filing moot like that. So, 2, plaintiff's amended motion for leave to file amended complaint is denied. The case will proceed on the original complaint. That's document 1. So that is the original. I think one day we need to go back and read it so we know we're going to have that trial. Now we know how the complaint is going to work. Again, discovery for that and additional items. That doesn't mean every item that is noted there, it's all just locked into that and that's all. But it's more a succinct argument. 16 pages, 2 people, you're going out. Huh. That's just like I said. There are a lot of animals out there flipping their fins. Oh, we won. What'd you win, man? What did you win? I mean, at some moment, maybe if 2 brain cells accidentally collide in some certain people's heads, they'll figure out, wait a minute, we're standing alone in this litigation yet again. Oh my goodness. It is absolutely amazing. You know, another thing that doesn't help you in court cases, the whole idea of being indigent, not having money, doesn't keep you from being sued. That doesn't mean that people without money can't do bad things. Like, they can use that as a defense to a point, but they can't use that as an out and out defense forever. And they lock them into more, again, statements that, woo-wee, man, if it turns out that money is being funneled into a bank account to try to obscure money that is going through, that money that was raised should have been going straight to LP and JC. But it wasn't. And why? Anyway, I wanted to go over these. I'm not going to have a crazy long live stream tonight. I'm going to go over super chats again. I got to spend a little time visiting Yield ER. Like I said, I'm okay and everything, but I'm going to go through stuff, and we will probably. I wanted to do the David the Donor stuff today, but I think I'm going to do that tomorrow. Because of all of this, it's quite a bit. Like I said, it's going to be funny to watch people fight back and forth and argue about the meaning of this. There was actually 1 second here. Let me find something real fast. I'm going to check one other thing. I sent something to myself, and I can't remember if this is I want to make sure that this is this is about the David the Donor thing. I can't remember. I sent it last night, and oh no, that's on the David. Okay, so we're gonna hit super chats. There was a fascinating. People have turned on Stupid Dave over this to the point. I mean, wow, wow. We have also had, again, turning on Guapo. Ray, by the way, this was fascinating. So I think I'll bring this up on the donor thing. So Ray, the Bone Crusher, said that he will no longer be commenting in people's lives. He will no longer be making comments there because he can't stand super donor. He doesn't like David, but he doesn't want to cost them money. Isn't that fascinating? I thought speaking the truth, damn the consequences, that should be the way to go forward. I mean, if you're a just and upright person, but no, apparently not. It's amazing how much butt kissing and more for relevance that goes on. But the donor saga, it still continues. And again, apparently we're not going to get transparency. Okay, that's fine. We'll see. So hello, thank you for the 5 gifted memberships. Thank you for that. Appreciate you kicking it off there. Thank you very much. Sticky Widget, thanks for the 10 there. Tug and I settled out of court. I now work for him for 0 pay for the rest of my natural life. I was pro se, my lawyer may have been adept. But I'm told it was a good deal, so I took it. Yeah. I know. Those pro se lawyers, sometimes they give you the best advice, don't they? And sometimes it was the best of times. It was the worst of times. Stick it Widget. Thanks for the 5 gifted memberships. Appreciate that as well. Thank you, Sticky. I appreciate you. So I knew if I made jokes about, Sticky bringing up something, I knew that Sticky would take it in the way it is intended. We could have fun with it. Indeed. Slug, thanks for the 2 there. We'll be able to watch working on the VTuber Talk. That's right. So Slug has been, we were talking briefly the other day because I was trying to bring up those moving pictures to have a little discussion with that, and Slug was like, hey, maybe that VTuber stuff would actually work out. I was like, yeah, wouldn't that be interesting? The moving umbrella. Whoa, man, that'd be strange. I mean, straight to your screen, baby. Oh, that's cool. And Slug, thank you for checking it out too, buddy. Juliet, thanks for the 5 there. I'll be sending some things to the girls soon. Thank you. Appreciate that. Make sure, with the P.O. Box, it's P.O. Box 151 and the address and everything. If you need it again, people can post it. If a mod can post it. But also, if for some reason you don't have the 151 one, just make sure to ask. And thank you very much. Appreciate you. Sir Walking Tree, thank you for the membership. Thank you. Welcome. Thank you for the membership. Welcome to Tugs Thugs. Man, I wish my beard would grow like that, by the way. Bam. That's what I want. Check. Painting LSK. Thanks for the month there, Tug. You're single-handedly ruining my sleep routine. But it's so worth it. Thank you. Indeed. Well, maybe you can get a little sleep. Actually, let's see, who's on tonight, by the way? Who is actually going to be broadcasting tonight? Let me look. Is everybody on the Friday night thing tonight with Expert? Is that where everybody goes tonight? Yeah, that's what I thought. All right, let me set my redirect before I finish everything else. I'll actually set it before I forget, because you know me. I will forget otherwise. Give me one moment. I'm getting better at redirect. See, look, I've already got it set. Isn't it amazing? I find basically you have to search out the live stream first, because their search tools won't find it for you. But thank you for that. Thank you for your sleep time. I hate that you're sleep deprived, but I appreciate you here. Subi Sue. Thank you for the gifted membership. Thank you, Subi Sue. Appreciate you. Carol. What's up, Carol? Thank you for the 5 gifted memberships. Appreciate that. I'm dropping 5 giftos out there. That's awesome. Man, even though it's short, we're only 2 freaking super chats off of 50. I mean, even then, on a short live stream. Thank you, folks. That's crazy. Max Lab, thanks for the 2. You're the best Tuck debunking time. Well, thank you, man. And props to Max Lab, too. Like I said, Max Lab tries to make sure everything's sent out, make sure that lots of people see it, know everything is going on. Props to you. Props to other people that do that as well. It is a lot of help. That way if documents do come up and for some reason, like when you have, like today, you had multiple things happen. So this allows the rest of the case to start moving. And it should really start to get interesting from here. If you think things have been interesting so far, boy, you haven't seen nothing yet. Just wait until discovery gets frosty. That's when things are going to get really, really interesting. Donna, thanks for the 15 months. Been following since before the JD trial. So happy to have a membership again. Well, I'm glad that you got that there. Thank you, Tug, for all you do. God bless you and the girls. Thank you for covering this case. Hey, thank you all for being here. Again, appreciate it. It also, it's just interesting to have a trial that's so wild. And it's also interesting to be able to go out and to really discuss what happens in a trial with these motions, because a lot of times you get the weirdest spin to some of these motions. And I'm like, is that really what that says? So, yeah. To Zad. I'm not sure how I go with all of that there. Hey, thanks for the 2. I am 4'9". Here's what I've done. Me, I am closing in with, I think I shrink over time with shoes on, though. We're clocking like close to 6. So I feel like these days, man, I'm like 6'3", though, as I get older. So who knows? But regardless, I'm tall. Okay, I'm tall. And when you're sitting in one of those little bitty push beds, man, those things are just tiny, and they're tiny on the sides too. You know, especially when they always pick you. You know, they always give you the old IV bag, the way to take blood and stuff. So it's always there. So you can't use your arm. Like for me, I bring a tablet so I can read. You know, like I said, it doesn't help you if you're panicky there. So I bring things to keep your mind is your own worst enemy when you're sitting in a place and waiting. So I appreciate you there for that one, by the way. Sticky Widget, thanks for the 5. I got a bell, damn it. I wish I could stay. I'll catch up. It's going to be a burner. Indeed. It was fun, too. It's thanks for the 2. You better take care of yourself. Or Megan in the chat. I will not deal with it very well. I do. That's why, again, I had some concerns. My heart didn't feel right. So we can get it checked out. I'm going to run a full panel, though. I'm going to go to cardiologist, run a full panel on everything, and make sure it's all good, because as you get older, what you're worried about years ago and what you worry about at the time, you just want to make sure you're good to go. So I'm going to do a whole panel run up. That's all scheduled, and we'll see. Any needs, run across that then. Mistrust Loop, thanks for the 2. Piss off the haters. Breadstick money is breadstick money. Love it. Thank you. Trissus, thanks for the 2 there. They're going after you for defamation and harassment. Defamation and harassment. Yeah. Transparency. Requesting transparency is apparently harassment. Man, the fuck you say? And defamation. You are running a scam. You refuse public transparency. You violate the terms of service on the very platform you're using. Defamation. No. The platform considers that a violation by itself. The way that that's being run. We're gonna sue you all. Okay. You better have all your ducks in a row when you do it. Again, that's gonna be a fascinating weeks. Thanks for the 10. Hope everything's okay. ER visits suck. Take care of yourself, Doug. Yes, indeed. Thank you. Appreciate that. Dan, thank you for the 2 there. When you know, and sometimes you know, right? Indeed. David, thank you for the gifted membership too. Thank you very much. Appreciate that. SCSF, thanks for the 2. I'd rather have BBB driving this dumpster fire. That's what I'm saying. That's what I'm saying. They're going to sue over that too. Oh my God. He said he'd rather have BBB because he's incompetent. It's defamation. Max Lab, thanks for 2. Lisa refused to get served for depot today. Yes, apparently there was some discussion about that too. If they have refusing service, you know what? You know what you should do? If the courts tell you not that you have to show up, don't show up. See how that goes. See how that goes. Refusing service. Okay. Let's see how that one plays for you. Oh my goodness. David, and brag about it too, right? David, thank you for the membership. Thank you. Welcome. Thank you for the membership. Welcome to Tux Thugs. Thank you for that. Appreciate it. Zohan, thanks for the 2. This avatar looks like Tuggy Crockett. Yep, he's the king of the wild frontier. He's the king of the E-Wild frontier. Thank you. Amy, thanks for the 2. The 2 tons when I'll yap their way into a zebra case. I mean, we went through one of the transcripts just looking at the claims that they made about Jeremy Hales were insane. They were freaking insane. Just in one transcript, and there are quite a few of them. You know, Cindy, thanks for the tune. Manskin cracks me up. Yes, indeed. Indeed. Suzanne, thanks for the 5. For Robert Tower, whose fur baby passed. That sucks, man. You know, love to you there. You know how instrumental. You know, they're not pets, they're family. A loss of family is a loss of family. So love to you there. You know, sorry for your loss too. Yes, indeed, buddy. Yes, indeed. And thanks for the 5 there. Can JC go after bubbles in a separate file? Can include the walrus? Yes. 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 This is just saying, see, in the federal case, what it's saying is this particular case would be slowed down and the client's inconvenienced if at this date this were to happen. And it went through the reasons why you couldn't add them to this particular case. That's not saying that you couldn't have cases against. That's not what it said at all. So, oh yeah. Oh yeah. Shizzy, what's up, Shizzy? Thanks for the 2 there. 1 ticket for the short bus. Man, I wonder if it has a lot of headroom, though. And a lot of headroom, too. AJ Stone, what's up, AJ? How's it going, AJ? Hope you're doing good. 10 memberships there. Boom. I saw a row of them pop in from you, AJ. Thank you. Thank you, all of you, for memberships. Thank you for a good live stream, too. Appreciate y'all. Right Chick, thanks for the 10. I could care less for LP and JC's best interests. All they had to do was shut the fuck up, and none of this would have happened. Their problem if they have an attorney or not. Yes, but the court, see, for you, yes, indeed. For many of us, we're like, eh. But with the court has to look after the best interests of not just them, but also for Jeremy Hales. It has to look out for his best interest in specific items too. So, two-way street, you know, and you want to judge that is fair and impartial. If he looks at this stuff and he says, hey, this is an undue burden, this is a problem in this particular case to have these people removed, and he laid down reasoning for it, his reasoning, it made sense. And also, like I said, I think the line about the streamlined case makes sense too. 16-page complaint, 2 people you're looking at in this particular case, and some of the stuff that was alleged was so bad. Well, we saw the comments on that too. So, but yeah, I hear what you're saying for sure. Emma, thanks for the 5 there. Missed a bit of the start of the stream. I hope everything went well. Hospital, being bedside. We need you to be healthy. Yeah, well, there were a couple of irregularities. There was they grade you. They add points for whether or not they will keep you. Now, they will allow an entire workup. You'll be there forever and a day if they do it at hospital speed. But what they do, they primarily look like if you're having irregularity, they check to see if your EKGs are coming in right. And they also check, they do imaging to try to see if they see any blockage or anything. That is an immediate concern right there. Those 2 things, immediate concerns. You know, my EKG is always a little odd, you know. So that adds a point. They did it. It's the same baseline, but it's the same baseline it was a while back too. So is it odd? Just a little bit. So that adds a point. Age adds a point. Complaints add a point, and so on. You know, there's a point system, but the point system was low enough that you're not looking at an immediate threat to hell. Like you're not gonna. They feel confident they send you home. That you shouldn't have a problem. Now, if you continue to have problems, you know, if you continue to think, oh my God, something terrible is happening, then. But yeah, I mean, they did their due diligence. So I'll follow up, like I said, next week with a specialist on that, just to make sure nothing's there. But yeah. Edie McGeederson, thanks for the 5 there. By 2 L's, running a scam fundraiser, donations, or whatever they want to call it. This not be money laundering. I don't know about money laundering. I would think I have to look at the particulars of putting money into someone else's bank account and then funneling it in. Well, this person's claiming they've got money now. They have this, they have that. While you're claiming indigency, that's kind of... And then again, you know, there's the forward-facing issue, too, of when people are giving money for a stated purpose, is there any money coming out besides for that stated purpose? Again, the whole idea, I don't think it's too much to ask for transparency. But apparently that is. Apparently asking for transparency is a threat. If you're like, hey, if these people aren't going to give it to people, then that's a law enforcement concern. Or a proper authority's concern. Okay. Navy Bet, love for the bro. Thanks for the 10. Wouldn't it be considered a scam as well? It's possible China Glam for taking the glyphs given to actually selling them. John doesn't deserve the items. It's very concerning. Yeah, the whole flea market thing actually though is there's a lot of confusion on where a booth was and everything else. You know, so if that indeed happens, that would be a problem. But I would need to see more on that because the booth thing, like I said, there was a bunch of confusion on that video. The way it was filmed was a mess and so on. Like, I think that's what a lot of people are referring to when they talk about that. Now, Ian, thank you for the membership. Thank you. Welcome. Thank you for the membership. Welcome to Tux Thugs. Thank you for that. Appreciate you. Yeah, SF, I think this here, personally, the judge did. Plaintiff's a solid today. Yes, that's what I'm thinking. That's the way I took it. Again, when you look through it and you look at it from a jury perspective, always look at cases from a jury perspective. That's where you need to be. As a jury, not as you. You can look at it from you, but most of you are probably smarter than the average juror. I mean, you know, we're talking averages because you may have some smart jurors, but you're going to have some people that draw that down. You know, some people that are looking for Matlock cases. And this is a crazy case too. This is a crazy freaking case. So with the signs and everything else coming up, that's going to be, that'll actually hit home for them too. And I think that that really does a succinct 16-page, boom, just hit it solidly. That might well be, and again, BBB on top of it. Wanda, thanks for the 5. Tug, I have news. My sister passed away. So it leaves me one sister and one brother left there for the 5. Oh, man. Wanda, I hate hearing that. Again, love to you. You know, it's rough, and that goes on. In the moment, it's hard to remember, too, that the reason we mourn is because we had great times with people. As we get older, too, we have more and more of those moments in our lives, you know, as we're the ones still standing. So love to you. And over time, hopefully, you know, keep those positive memories. Sometimes people are rushed into making decisions about, like, property. And I don't mean, like, housing and stuff. I'm talking about, like, items, personal effects. Sometimes those are tied to really positive memories. They can hurt when you look through them, but they can also remind you of the positives. So, again, love to you. I hope you and yours, I hope y'all are doing good in this. It's a rough time. Yeah, love. Chat also. Give love to people that need it as well. Thank you. Mama, thanks for the 5 there. Mama Lori. Mama. It sounds like I'm talking to my mom. Hey, Mom, what's up? Mama Lori, thanks for the 5. I recall JH mentioning that those not included in this case would be sued in civil court. Interesting. It's potential. I mean, again, this includes one case. So we'll see what happens. I don't know. This stuff is far from this case right here. It's just kicking up, and it's on like Donkey Kong. So Lee, thanks for the 10 there. Supposedly Lisa refused being served for depot. Yes, that's what's been noted there. That's okay. What a plan there, right? Just a second. Let me look something up here for you, okay? Just give me 1 minute. 1 second. So, knowing your rights, you have to be, you have to understand that if service is done correctly and someone ignores service attempts, fails to respond, fails to accept them, and they're bragging about that there, courts, they can issue fines, people can be arrested. You can end up with judgment. So that's not the smart way to go. It's not the smart play. But like I said, hey, what do I know? Right? What do I know? It's the greatest play ever. Smartest thing to do. I mean, really. Stacey R, thanks for there. Read the last footnote, please. Did I skip a footnote? Let me check. Give me 1 minute. Oh, I did. I did skip the 5th footnote too. Yes, I noted this stuff too. I did skip a footnote. I apologize. I thought I had included that and I didn't there. So listen to this. There's a pending motion to dismiss filed by defendants regarding 3, 4, 5, and 6 of the complaint. I noted this at the beginning, but I should have noted this here. I should have read it. So my bad there. There's also a pending motion for summary judgment filed by defendants regarding count 1 and 2. For planned purposes, the parties are advised that the court is drafting a separate order that will grant the motion to dismiss with respects of count 3 and 4. Okay. So like I said at the beginning, the tortious interference and defamation. But we'll deny it with respect to count 5 and 6, the tortious interference with business relationships. The parties are further advised that the court is drafting a separate order that will deny the motion for summary judgment. Again, the court is going forward. My bad. When I noted this, I kept thinking, I said it, but I didn't read it. I should have read this too. My bad. I got excitable in there. Thus, the case against the defendants, Preston and Cook, will move forward on the complaints of defamation and tortious interference. So this case is on. Like I was saying at the beginning, this case is tortious interference and it's defamation. That's what goes forward. So it's 100% on. They kept talking about they were going to get summary judgment and everything else. That's not happening. It didn't happen. And this will be something fun to laugh about too in the next live stream. It needs its own proper time to laugh about. Yes. I should have, like I said, I noted that at the beginning, but I should have read it as well there. But yes, so the summary judgment gets struck down. So they were denied by that. They were like, oh man, we want this whole thing shot down now. Now, as far as RICO, the RICO counts, it is not moving forward with that. So counts 3 and 4, okay. But as far as tortious interference and defamation, the defamation claims, they are, you've seen what's there with defamation. This is what this is bad for them, because they kept saying that this case would be done. Trial's on. It's on, like I was saying. It is definitely on. It's 100% on. Everything that we've gotten there shows you that it's on. No summary judgment, no dismissal. You have it streamlined to defamation and tortious interference. Tortious interference, again, if you do not understand that, I get questions about that all the time. Tortious interference, the easiest way to understand that is you have a business relationship, right? It's an A-B relationship. You know, party A, party B, and somebody sees their way into it. So party C shoves their way into that. That is tortious interference. That is how that works. You prove that they did it. You prove that the damages, bam. Defamation stands too. Those signs are so bad. They are a real problem for them. They spent a lot of time, again, trying to minimize the damage that the signs did. And I do not think that they did a good job of it at all. The whole idea that only 3 people supposedly see this. Oh, business, the busy highway. Can you prove anybody saw that? Are you kidding me? I mean, are you kidding me? But yeah, thank you for noting that too. Vanessa, I'll keep that up there too. Thanks for 5. Tug, sorry about the entire chat. Let's read the footnote. They're repeating it. Yeah. Well, I'm glad everybody noted that too. That's what we're noting at the beginning. So, man, maybe I should skip a footnote one time. Look, there's a bunch of people that noted that. Read footnotes. let me shout out everybody as a let's see. I'll shout out everybody as a title because I don't have to read them every time. Actually, wow. Vanessa, thanks for 5. I'm just kidding with that. Thanks for the 5 there. Roll Bird shot a 5 on that. Thank you. Rio Rai shot a 2 on that. Gail shot a 2 on that. Lindy shot a 249 on that. And Tracy, thanks for the 5 there. Can't wait to hear the depo from Hater L1, and we'll see what happens with that. What is 3 and 4? That's RICO. So RICO is a conspiracy. So the conspirators are gone. You're not adding them to this particular case. Okay, that's a good question too. So as far as the case is concerned, you streamline again: defamation, tortious interference. Remember though, we were told this whole case is done, baby. Everything's gone. But the court's told you, deny and deny again. So the court has denied a summary judgment. The court is allowing the case to move forward. The court has said they're not going to allow, since there was over the 21 days, and if he would have filed, and again, looking at the arguments there and imagining a jury, you make your own decision on this, but I think it's much easier to prove that Lynette Preston and John Cook are the ones that did this to you. It's much easier to go with that and to hit them with that right off the bat. That's my personal belief on that, like for this case. Oh man, could you imagine the depo from that? Oh, that'd be funny. Pickle Tink, thanks for the 5. Glad to hear that's all okay. I'm home from the hospital myself. Why? I remember you say that everything was going good for you too. So that's good. That's good news. Everybody needs good news lately. Thank you. Thank you. Kathy also. Look, there's some more footnotes. There's thanks for the 2. So lady, thanks for the 2. Susan, thanks for the 2. Man. That's hilarious. But thank you for the membership. Thank you. Welcome. Thank you for the membership. Welcome to Tugs Thugs. I was a little off my game too. Like I said, I spent my whole night. I spent 8 hours there. I slept part of this day. Today, I was supposed to have another doctor appointment today, and I couldn't even go to it. Like I couldn't function. I was like, oh. So yeah, that'll hit when it hits the next week, I think. But I just couldn't even function today. I actually thought I thought about if this motion didn't come in today, I probably wouldn't have live streamed today. But I was like, man, you know what? We definitely need to, because I saw like it's funny, all these weirdos that they're like, it's over, and I'm like, no, actually, it's really getting going now. It's frosty. This is a frosty muffin. You got some sprinkles on it. And if you think that the evidence proved that John Cook and Lynette Preston did horrendous things that damaged this man's business, they're making threats and more. Now it all just focuses on them. So, and again, it's streamlined. You don't have the idea of conspiracy that's in there. It's very streamlined. So, Lonely, thank you for the 5 there for 50. We actually going to be 150 now. Thank you. Appreciate that. And Palmer, not Archer, Homestead, thanks for the 5. Did I miss the bug ray? No, they are over with their grandmother today. So looking forward to meeting you and Megan in August, if not sooner. Indeed. I think that will be fun. Siggy, thanks for the 2 there. Can JH bring separate suits against? Oh yeah, yeah, of course, yes, very, very much so, very much so. Shannon, thanks for the 3 month suggestions. For getting seen faster, chest pain, trouble breathing. They don't like leaving those patients. But yes, that's why I went up there. Actually, chest pain. So he went in real fast. But to get in, they did the EKG right off the bat, and then you sit forever. They were like, imaging's running behind a little bit. It could be anywhere from 2 to 12 hours. I was like, what? What? So if I'm having a real problem, like there's a blockage, and that's not good. It's not very good at all. 2 to 12 hours. Hey, just sit here. Now I get again, hospitals get crazy and stuff. It's just like, ugh. Emma, thanks for 2. It's not defamation when it's true. I know. And they're saying they're going to sue me over it. Indeed, right. Vanessa, thanks for the 5. Sorry for repetitive super chats. No, there's no problem with that whatsoever. If you want to say the same thing 37 times for pay, I have no problem with you saying that whatsoever. That was actually, all jokes aside, for real. That was my bad. Again, I mentioned it at the beginning and I didn't hit the footnote at the end. I don't know. Just one of those. I meant to pull it up at the beginning and to laugh at it at the very beginning, and I got sidetracked by something else, and I don't remember what. So, Richard, thanks for the 5 there. Do everything. We get so much entertainment from the onset. No, I did not think that this case. I thought it would be an awful case. It would only. I didn't know where it would go as far as lawsuits for the federal component. I didn't know where we go there, because really when we first started looking at this stuff was just about protective orders. That's all we were dealing with, right? 2 protective orders, and that's it. Then it became this other beast. And another beast, offshoots of it. I mean, it's wild. And remember, we have stuff coming up in February, talking about the thumbnail litigation and what's going to come with that. I mean, this stuff can get very, very interesting. Terry, thanks for the 5 there. Aren't they using HG for all fundraising? Isn't that abuse of a child? As far as law, not really, no. You see people go out and run dozens and dozens of freaking charities, some of them legit, by the way, that involve child. The way that it's presented, now if the money's not going to a particular thing, that's an issue. The statements of money, see, the Shara statements are concerning too. Like, just to be truthful about it, because she's claiming that money was raised and she gave money for items that it wasn't. She contacted their lawyer about that. He was like, I have nothing to do with this. So that's another thing I would actually want to note to proper authorities as well. If contact to proper authorities happens and BBB shows his ass in there, I thought he didn't have anything to do with that. That's what he told Shara. So if he decides to insert himself into this kind of stuff, isn't that fascinating? He wouldn't do it for a Shara and the money that was discussed. We'll see. We'll see what happens. Yvonne, thanks for 5. What if LPJC plead the 5th at the depot? Would that be a problem for them? It would be a problem in the fact that they're refusing to answer questions. Yes, that would be a problem. You have the ability not to incriminate yourself. But if you don't go out and give any answers and something, you realize, first of all, how that would fly. You saw the courts tell Jeremy, for example, you need to answer on certain items. Like you need to answer about business and how business is actually impacted. You need to talk about, this issue or that issue. The courts would be like, yes, you can answer. But you just think, in a perfect world, say you got to go in and you get to say, I'm not answering anything. I'm not playing, and you did that, right? How do you think that plays? How do you think? Again, if you're going to jury trial, what do you think that would say? I just think that's funny. That'd be the dumbest mistake ever to do that. So that maybe they should. Marcus, thanks for the 10 there. Hope things are okay. Indeed. Thank you, Marcus, too. Appreciate you, my friend. Emma, thanks for the 5. I'm glad you went. May will never forgive you if you were. Indeed. Actually, funny thing is, when I was going over there, I thought, I might say something about it publicly. I might not. I messaged me. I was like, don't freak out if you see me post something about that. I'm all right. I'm good to go. So don't freak out. So to tell her that, actually. Because, I mean, for real, all jokes aside, they're over with some very serious stuff right now with Jeff trying to get closure. And I don't want to add to that burden in any way, shape, or form either. KC, thanks for the 5. Hubby had a widowmaker heart attack years ago. He's okay. Has a defibrillator 4 years ago. Amputation below the knee. He's doing good. Take care of yourself. Indeed, it's horrible too. I've had a guy that I worked with that had all these signs of heart attack. The sweating and it just. I mean, you could tell he was having some real problems, and he went in, and sure enough, he was having a heart attack, and it saved his life. So I never forgot that lesson. When I was younger, I mean, cost does. Unfortunately, going to an ER is exorbitantly expensive. So a lot of people pass on that too, and it's a shame in the U.S. especially. You make the choice. Do I spend? Are they going to be competent too? Shouldn't be that way, but it is, unfortunately. Sue, thank you for the footnote as well. Thank you for that. Zoa, thanks for the 2 there. We had trespass 5. Now the separate suit 6. I love it. If it comes up, we'll call them the separation 6. That'll be funny. That'd be interesting. A World Explorer, thanks for 5. It won't be jail, just monetary punishment. They need to be jailed, or else they'll keep on regardless. Judge, is the judge barred from jailing them? Thoughts, Tug? The judge themselves can refer you for investigation. A judge can do that. So, I mean, that's where you run into. The legal system's a mess, though. Let's just be honest. It is an absolute mess. It runs on money. Like for Jeremy Hales right now, the amount of money that he's had to spend, do you think he's going to recoup that money? No. But he needs to clear his name because these people called him an ARPist in a PDF file. He needs a decision that says that he's not any of these things. There is nothing that has ever been alleged in court on that. It's never had anything, never been found guilty of anything even closely resembling that. That right there, again, it's a life-destroying accusation. Even if you don't have anything on you, the accusation itself is on you. That can be a mess. So yeah, justice there. But anyway, let's be done. We will probably do a live stream tomorrow. I'm feeling it, I think. We'll see for sure, but I'm pretty sure we will have a live stream tomorrow. And we're going to go over to the expert. You all have fun. Tell them that we're tug raiding, and see ya.